So our book has a pretty in-depth analysis of jurisdiction and procedure and remedies. And one recent issue that has come before courts is whether discrimination claimants should be able to get fast interim remedies from the Employment Tribunal. What do you think about that, Pauline?
Well, yes, very interesting decision. Steer and Stormshaw, which has now been to the Court of Appeal, and both the Court of Appeal and I think the Employment Appeal Tribunal before the Court of Appeal said no. Interim relief is a statutory remedy. It's only available in certain very specific circumstances. So it used to be trade union activities, health and safety related activities. And now, of course, it's moved on a bit more because whistleblowers, so-called, can also claim interim relief. And that was really the basis on which I think the Steer and Stormshaw argument came about. Oh, well, you know, interim relief, if it's available for whistleblowing, isn't that akin to it ought to be available for discrimination? But of course, the problems that that would create are massive, I think, in terms of the way that interim relief operates, really. Because it's essentially a paper exercise. The judge has got the claim form. They might have a response form, they might not, because they get listed very quickly. They might have written submissions, possibly written witness statements, but it's not a case where you hear evidence or people get cross-examined. And how, at that point, you decide as a judge, is this likely to be the main reason for dismissal, the fact that this person alleged discrimination or something like that? Is that likely? I think that would be very difficult, because the discrimination exercise itself is much more about something which has an influence on a decision, but is not necessarily the main reason for it.
It's really interesting that there's not many interim relief claims at the moment, because they're mostly trade union representatives or health and safety representatives, and as you say, whistleblowers. And if I think the Court of Appeal was looking not only at whether or not it was discrimination between claimants of different status, a whistleblowing status claimant and a discrimination status claimant, I think the AT said it might be a breach of Article 14. The Court of Appeal said no, it's not a breach because we have to look at the whole package together. But the Court of Appeal were looking at the practicalities. How on earth would you not bring an interim relief claim as a discrimination claimant if it was there open to you? I suppose the tribunal might get flooded with claims if... I
think we would. I think we'd be absolutely inundated, and ultimately it would be a complete waste of time, because the likelihood of getting interim relief is very small in any event, because it's quite hard for the claimant to put forward a positive case that this is what the tribunal, who has heard all the evidence, is going to say the reason was for my dismissal. I think
you have to have a pretty good chance of success, don't you, in order to get some interim relief?
Pretty good, I think, has now been clarified to be almost a racing certainty chance of success. And the other thing I think that really is a strong reason for not extending it, unless legislation says it will be extended, is that actually, although people say whistleblowing is akin to discrimination, it's also akin to representing a wider public interest. So the trade union rep who goes in to complain that people are being asked to work unsafe hours, the health and safety rep who goes in to say that the machinery isn't safe, the whistleblower who says that the organisation is doing something untoward and gets dismissed the next day. I think you can see in those circumstances that there's a real case for interim relief if the connection is so obvious. So, you know, like I say, you blow the whistle, you're dismissed the next day. It might be that it would be quite easy to decide that that person actually should get interim relief, but I just don't think it works in discrimination cases at all. And I certainly don't think it's for the courts to effectively
this is one where
the
if we're going to change this, it needs Parliament to step in and say, this is what we want the courts to be doing. I think courts making judge-made law would be very, very problematic in this particular instance.
Well, it would, and I think it would be wrong in principle.
Be interesting to see if the Supreme Court are troubled by this point. Watch this space.